Hello again, everybody. Glenn Russell Donaldson with Velocity National Title Company. And I want to take just a few minutes and talk about something that has really become an important issue in recent months. That is the earnest money deposit, the EMD. So let's go down in history just a few years and talk about how the earnest money deposit was handled traditionally. So if a buyer was purchasing a home, they'd write an earnest money deposit check as part of the contract of sale. That check would be delivered to the listing broker, the broker who represented the seller. And the listing broker would hold that money in their trust account as a fiduciary to the seller. In recent years, the real estate brokers have decided that they really don't want to hold the earnest money deposits any longer. And the reason for that is because occasionally there was a dispute that would arise between the buyer and the seller. And when there was a dispute, that sometimes required the parties to litigate. And in such an event where they wouldn't release each other from the contractual obligations, the earnest money deposit would be at issue. The real estate broker would then have to file an action in court called a bill of interpleader, and when they did that, it was costly to the real estate broker, and they've decided, many of them, that they don't want to engage in that sort of litigation and be a party to a buyer and seller's dispute. So what they've done is, in recent years, they've asked the buyers to make the check payable to the title company that's going to be conducting the real estate settlement closing. Now, in doing so, the questions which have not been answered by any court or the regulators that are being raised is, where does the title insurance company hold those money? And are they, in fact, a fiduciary to any of the parties? Well, the answer to that is no, they're not a fiduciary to either the buyer or the seller. But they have to handle the trust money in the same way they would any other money. But it goes into the account that is an escrow account called a MOT account, a Maryland Housing Authority Trust account. So what is the issue? Well, the issue is that the Maryland Housing Authority Trust account is not a regulated account by the Maryland Real Estate Commission. Instead, it is a regulated account by the Maryland Insurance Administration. Additionally, the real estate company is a fiduciary to their clients, the sellers, when they hold that money. A title company is not a fiduciary to any party. So in the event that there was a mishandling of those funds by a title insurance agency, the real estate broker's client would not have the advantage of making a claim to the Maryland Real Estate Commission and the guarantee fund to recoup those monies. If the title insurance agency were to go defunct or mishandle and use those funds in an inappropriate way and they were lost, the only recourse that a consumer would have would be litigation against the title insurance company. However, with a real estate broker, if the same events occurred and there was a loss of those funds, the consumer would have redress at the Maryland Guarantee Fund. So the question that no court and no regulator has yet answered is, does the real estate broker still have liability when they release trust funds of their client with whom they are a fiduciary to a non-fiduciary party to hold? Well, we'll see how things develop in the coming months and years. I would argue the real estate brokers might want to think this through just a little bit more. We'll talk more next time. Glenn Russell Donaldson at Velocity National Title.